Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 139. I'm conscious there's been an additional week's delay in this. Unfortunately, having been away for most of August, things got quite busy, which at least keeps management happy, but does occasionally get in the way of doing this podcast. Anyway, of course, we have 3 cases for you this time round. Well, actually, no we don't. We only have 2 cases, because they're both quite lengthy cases. I did think of including the tribunal case dealing with the individual who was effectively let go by his employer after they found out that one of the references he'd provided was using an alternative name for Jabba the Hutt, the Star Wars character. Quite imaginative, but given that he was applying to be a commercial airline pilot, deeply unwise. I imagine the Employment Tribunal had trouble keeping a straight face with some of those facts. Anyway, we've one case dealing with some quite important points in connection with constructive dismissal, and another equally important case on adjournments in internal disciplinary hearings. Then, as a reward for sticking with me until the end of the podcast, I have got a podcast recommendation for you. Please don't forget, of course, you can access the podcast via iTunes. It's on the Mayor Brown website, YouTube, Twitter feed, and the Twitter handle, Nicholas ROBER11. That's Nicholas Robertson at Nicholas ROBER11. And that's also where we post out the links to the cases discussed, not the Jabba the Hutt one, I hasten to point out. Although I could do, I'll see how I feel. Anyway, first up, Talon Engineering Limited and Smith. This is an EAT case, and I think it causes a problem for employers. I certainly think you can anticipate that if you're working in a unionised environment or individuals are looking to bring trade union reps in to represent them in a disciplinary hearing, this case is going to get a lot of airtime. Well, claimant worked for employer. She'd worked for employer since 1994. She was summarily dismissed on 30th September 2016 for misconduct. She'd sent, apparently, some relatively rude emails about colleagues and had attempted to delete some other emails which apparently were quite unflattering about her colleagues. Anyway, the Employment Tribunal decided the dismissal was unfair on procedural grounds. And the procedural grounds were that the employer, the respondent, had refused to postpone the disciplinary hearing for a sufficiently long time to allow her to be represented by her chosen trade union official. Okay, that's the context. Procedural unfair dismissal. Now, the chronology of the disciplinary process goes like this. 29th July 2016, she is suspended. She's asked to attend an investigation meeting on 9th August. During that meeting, no evidence was actually shown to her. She is then invited on 26th August to attend a disciplinary hearing on 5th September. She is sick. So gets adjourned. She's then on annual leave. So on 19th September, she's invited to a disciplinary hearing 10 days later, on 29th September. When the hearing was announced for 29th September, i.e. 2 months after she's initially suspended, her union officer, who'd been representing her throughout, said he'd be tied up on that date, and his earliest availability was mid-October, i.e. just under 2 weeks later. The employer refused to reschedule the meeting. It said there'd been a considerable period of time from the commencement of the disciplinary process, and that there was an adverse impact on the business by having her on the books but out of the business. The further delay would cause strain to both the claimant and the staff covering her work, because they couldn't replace her whilst the disciplinary process was ongoing, obviously. The employer said, well, we're not prepared to tolerate further delay. It also made the point the employer was entitled to reject the amendment because the union officer was not proposing to attend within 5 days of the date set by the employer, i.e. the union officer was not exercising, or the claimant wasn't exercising her right under the Employment Relations Act 1999 to delay a disciplinary hearing by up to 5 working days for her official to attend. I'll go into that point in a bit more in a moment. Anyway, the claimant then decided not to attend the disciplinary hearing, and she was dismissed in her absence. After the dismissal, there was an appeal hearing, but the tribunal found that this wasn't a full rehearing. The approach to the appeal officer was to determine whether there were good reasons to interfere with the dismissal decision. And I think this is going to be key, as I'll explain. Anyway, The Employment Tribunal, as I said, found that the failure to postpone the disciplinary hearing made the dismissal unfair. It was far preferable, the tribunal said, for the employee to attend the disciplinary hearing, and all reasonable steps should have been taken by the employer in order to ensure that she could do that. The tribunal accepted in principle that if an employee is being difficult or trying to inconvenience an employer, or indeed if the situation has simply gone on for long enough that it's necessary to take a decision, then a disciplinary hearing could be done in the absence of the representative or the employee. However, here, the tribunal felt that that point had not yet been reached, and they said, quote, proceedings had not been on foot for a particularly lengthy period, unquote. Well, the AT was asked to overturn the tribunal's decision, and the employer said the tribunal had fallen into the trap of substituting its own decision for that of the employer, rather than asking what a reasonable employer would have done. Secondly, the tribunal had not expressly taken into account Section 10(5) of the Employment Relations Act 1999. That gives the employee a statutory right for the disciplinary hearing to be adjourned for up to 5 days in order for the employee's representative to be able to attend. Neither point did any favour of the AT, and basically the Employment Tribunal was found to have come to a decision that it was entitled to reach. Well, I have to say I find this to be a pretty surprising decision. Employers are generally told that they need to get on with the disciplinary process, and delaying for too long might itself mean that a dismissal is unfair. Here, the investigation started with suspension, or the process started with suspension, I should say, on 29th July. 2 months later, they're trying to hold the disciplinary hearing. This is already rather longer than the normal disciplinary process in my experience. I think it's clear the claimant was not seeking to delay the disciplinary process, although there was one bout of sickness in there which contributed to the delay. Equally, for the tribunal to have reached a decision without even referring to the 5-day delay provisions in the Employment Relations Act 1999 is obviously quite odd. Here, and I think with the greatest respect to both the Employment Tribunal and the AT, most employers would have gone ahead, especially when the employer had taken the trouble of setting out its reasons for going ahead and for not delaying further. However, I am in no doubt at all that this decision is going to get referred to on a regular basis. It's not exactly unknown for claimants and or their representatives to seek to delay disciplinary proceedings, particularly where the individual is facing significant allegations of misconduct likely to result in dismissal. Every day of delay is an additional day's pay to the employee. Potentially, employers are going to be placed in an invidious position by this case. Either they accept the employee does get to slow down proceedings and remains on pay for the duration, and the employer may be very, very suspicious, of course, about the reasons for the delay, or the employer takes a risk, says enough and no more, the claimant doesn't attend, is dismissed, and then runs the argument that the dismissal is unfair because the employer hadn't delayed enough. But I think this does cut both ways. If I was advising a claimant, I'm sure it's normally better to go along and present your defence at a disciplinary hearing. Would I be confident advising that the client absent themselves, accepting it makes it much more likely the dismissal or whatever will happen, and then you place all your eggs in one basket, i.e. the process should have been delayed? I also think it's quite odd that the tribunals are going to want to adjudicate every adjournment decision. The beauty about sticking to the 5-day provisions is that they're crystal clear. There's a statutory right to adjourn, and absent extraordinary circumstances, that is by and large what no further adjournments should be required. As it is, tribunals are going to be asked to decide is a 6-day adjournment, a 7-day adjournment, a 10-day adjournment. Are they all fair and reasonable? Anyway, I think the key thing to take away from this case, and very definitely with the benefit of hindsight, is that there should have been a full rehearing at the appeal stage. At that point, the employee, presumably dismissed, presumably off the books at that stage, would have a full disciplinary hearing. If the appeal hearing amounts to a full rehearing, then it can potentially cure any procedural fault caused by going ahead too quickly at the original stage. Obviously, if it were better if both the initial disciplinary hearing and the appeal hearing were conducted flawlessly. But making sure that there's a full rehearing may offer a way through if the employer is facing an employee who's apparently dragging their feet, but in a way that is difficult for the employer to prove. So in short, that's Talon Engineering and Smith, where the employer lost because after 2 months the trade union official wanted a 2-week delay and the employer refused to give it to them. So our second and final case, Brown and Others and Neon Management Services Limited and Others. This is a High Court case which was heard on an expedited basis, and it had to deal with a number of quite interesting contractual issues which were raised by the parties. Some of these are of general importance. I'm going to leave out the ones that are more specific. But since the decision was reached after a full trial in the High Court, live evidence, etc., it's an interesting example, and that some quite tricky contractual issues being worked through on the basis of live evidence and full argument. I would say a word of caution at the beginning. The decision is a lengthy one, and I'm going to cherry pick, in a way that Theresa May is apparently not permitted to do these days, some of the issues. Secondly, although Neon management lost on almost all the points in dispute, I strongly suspect that going into this hearing they saw matters rather differently from the judge, and indeed they may still believe that their concerns about the actions of the claimant were entirely justified, leading Neon's management to take the decisions and the steps they did. Although the facts were, by and large, surprisingly uncontentious, there were multiple different legal claims and subclaims raised by the parties. Broadly, and this is broadly, the claimants asserted that their employer had breached their contracts of employment by failing to pay salary increases and discretionary bonuses that were due to them, making salary increases and bonuses conditional on acceptance of adverse new contractual terms, and removing a profit commission scheme that had been agreed at the time of their recruitment. This led the claimants to resign, arguing that there had been a repudiatory breach of contract. They resigned on the 16th of March 2018 on notice. I'm going to come back to the significance of that fact later on, but the point is they resigned on notice. Claimants then asserted there were further breaches by the employer during the notice period, including paying the profit commission on a basis that had never been agreed with them. Also, it was alleged they'd made unjustified misconduct findings against the claimant and then reported that alleged misconduct to the industry regulator. There was then, therefore, a further constructed dismissal claim, which led to a resignation with immediate effect on 1 May 2018. The individuals claimed damages and confirmation that any post-termination restrictions fell away because there had been a repudiatory breach of contract. On the other hand, the defendants said there were no repudiatory breaches. They were entitled to make salary increases and bonuses, subject to acceptance of more extensive post-termination restrictions. The profit commission, they said, was correctly calculated. They were entitled, and in some cases obliged, to report misconduct to the regulator. And the post-termination restrictions now do not fall away merely because there's been a repudiatory breach of contract. So what was the contract? Well, each of the individuals, of course, had signed a contract of employment on joining, which contained reference to restrictive covenants contained in a restrictive covenant agreement. Interestingly, Clause 5 of that restrictive covenant agreement expressly stated that Neon could review the post-termination restrictions contained in the agreement in conjunction with any salary review or bonus award, and make it a condition of acceptance of the pay review or bonus award that the restrictive covenants were reaffirmed or new or revised restrictions were entered into. So one of the issues is whether that clause 5, provided sufficient cover to Neon when they sought to introduce new restrictive covenants here. I'll come back to that. Anyway, after the individuals had joined Neon, Neon did not prosper, although it seems that the individual team that we're talking about here was doing a good and profitable job for Neon. Therefore, there was a process in early 2018 for Neon generally of issuing new contracts of employment because the old contracts, allegedly, it was said, did not represent the culture and outlook of Neon. Changes were made to benefits, pension, holiday carryover, some leave entitlements. The restrictive covenants were revised and made more onerous. Each individual was sent a revised employment agreement handbook, and when the time came for Neon to brief the individuals, the claimants here, they were told that the bonus pool was going to be 70% of the previous year's amount, and the employer was going to calculate the profit commission pool, but making a deduction for notional losses occurred during the year. But the claimants contended the profit commission for them could only be calculated on deducting actual losses, and there were no actual losses to be deducted from the profit commission pool. Both parties dug in, and the three claimants resigned on 16th March 2018 at the same point. The resignation letters were not identical, but they were very similar because they'd all gone to the same lawyer. Each of them contended that their position had become untenable because of the proposed detrimental changes to the contract of employment and the rewriting of the profit commission scheme. Crucially, although all three letters asserted there had been fundamental repudiatory breaches of the contracts, all three gave contractual notice of termination rather than triggering an immediate end to the contract. One of the claimants had a 12-month notice period. The notice period for the other was 6 months. Now, one of the arguments put up by the employer was that by giving full notice, rather than simply walking out, all of the breaches up to that point had been waived. Well, things started to go really wrong after that point because the employer started to become convinced there was an element of set-up in the individual actions, and they were suspicious of their motivations. As such, their attitude seems to have hardened. The employer did a search of the individual's emails, for example, and 2 of the 3 individuals were found to have sent company confidential information to their private email addresses. This was taken up with the individuals, but a report was made to the regulator before the individuals had even had an opportunity to respond to the concerns. The report suggested that an issue had arisen with the 2 individuals requiring notification to the regulators. The claimant's assertion was they hadn't done anything wrong. The emails had been forwarded for the purpose of the employer's business, not their own interests, and it was not unusual for staff at the company to send emails to their personal address. It's clear from the exchanges that Neon management had convinced itself the claimants were engaged in acts of wrongdoing to damage the company's business and seeking sums they were simply not entitled to. This led to further angry exchanges and an assertion by Neon that the claimants were becoming increasingly disruptive and unprofessional and failing to perform their duties. And that was it. That was the end of the road for the claimants, and all 3 of them resigned on May 1st. The High Court made a number of key findings. First, Neon should not have reported the allegations to the regulator about the claimants without conducting a proper investigation first. Secondly, the claimant's contentions as to how the profit commission was to be calculated were correct. Therefore, the attempt to calculate profit commission on notional losses was a breach of contract. Neon referred to paragraph 5 of the restrictive covenant agreement, saying that they were entitled to make payment of any salary increase and the discretionary bonus for that year conditional upon the claimants accepting new and revised terms. And if you remember, they were trying to introduce more onerous restrictive covenants. High Court accepted, in principle, an express clause like this could allow an employer to propose unilaterally new restrictive covenants and then withhold a pay rise and discretionary bonuses from anyone who refuses to sign up. This clause was not limited to tidying up changes, which is what the individuals claimed. The court pointed out this was not a unilateral variation clause. Instead, the employer was not obliged to pay a discretionary salary rise or a discretionary bonus. And the clause effectively recognised it could choose to pay such a discretionary bonus on terms that required the employees to sign up to revised, more onerous post-termination restrictive covenants. It was not the case that the employer was seeking to introduce these unilaterally without obtaining the consent of the employee. The employer could put the employee to consent and then get the discretionary pay rise / bonus. So, there'd been a number of repudiatory breaches by Neon before 16th March 2018, which was the date on which the claimants submitted their notice of resignation. Remember that they gave due notice, 6 or 12 months, and said they were intending to work out this period of notice. The defendant's case was that by submitting the due notice rather than giving immediate notice and walking out, well, they'd elected to keep the contracts alive and therefore waived all the breaches prior to 16th March. Remember, of course, they then resign later on, so the part of the issue is whether they could take into account those earlier breaches. The claimants did not accept what the defendants were saying about giving notice, but said to the extent that there were breaches prior to 16th March which were waived, they were still entitled to rely on those pre-notice breaches if there were further breaches after they'd given notice. In other words, and picking up the phrase of the Court of Appeal in Kaur, K-A-U-R, and Leeds Teaching Hospitals, further breaches, i.e. after they've given notice, did not land in an empty scale. If there's a continuing cumulative breach, the employee can rely, the court said, on all the employer's wrongful actions, notwithstanding a prior affirmation. Therefore, provided there were acts, in this case, after the 16th of March, which contributed something to the earlier repudiatory acts, then the employees could subsequently resign, taking all of the breaches into account. And here, the court was very clear. By resigning on notice, the claimants who had a 12-month notice period and a 6-month notice period had affirmed their contracts of employment. An employee may not leave it too long before resigning altogether from employment. That's different from giving due notice. Here, the claimants who resigned on notice indicated they would be working out their notice period. Court said, quote, "It would be unconscionable to keep one's right to discharge a repudiated contract alive for that length of time in the absence of any further breaches of contract." Unquote. Remember, one of the employees had a 12-month notice period and the other had a 6-month notice period. There were 2 out of the 3 were affected by this point. And the court made this point in connection with both of them. So Giving 12 months or giving 6 months notice led to the same result. Breach is waived. So, pausing there, if the employer had then kept its nose completely clean after that, then the employee's constructive dismissal claims would have been lost because they gave due notice. However, fortunately for them, the court found there were then further breaches by the employer. For example, it raised concerns with the regulator which were unjustified, told the employees it had lost confidence in them, it made unjustified complaints about them, and therefore the court accepted that the employees were then entitled to resign with immediate effect on 1 May 2016. Finally, the court was asked to consider whether the restrictive covenants fell away because of the repudiatory breach of contract, or whether the restrictive covenants would still be enforceable. The employer had a go at arguing that the old principle, laid down in General Bill Posting Limited and Atkinson more than 100 years ago now, no longer applied. And it is true that there has been occasional judicial comment since then which indicated that maybe this repudiation rule is apt for reconsideration. But here, High Court was having none of it. First of all, the High Court did not seem to share the employer's view on the comments made in subsequent cases after 1909 about whether or not the rule was the right and proper one. More importantly, however, the court said that if you had to interpret the restrictive covenants themselves, there was nothing to indicate that they continued to apply in the event of repudiatory breach, and indeed there was something that seemed to point against it. Therefore, as a matter of interpretation, the post-termination clauses in this contract fell away on a repudiatory breach by the employer, because that is what was intended by the drafter of the covenants. So, there you have it. Brown v. Neon, a lengthy decision which shed light on various contractual issues. Sorry, I was never going to get through the podcast without making that joke. Anyway, Neon considers whether restrictive covenants fall away automatically or not on a repudiatory breach, whether the employer could contractually provide to have revised restrictive covenants in return for discretionary pay rises and discretionary bonuses, and crucially, whether resigning on 6 or 12 months' notice amounts to an affirmation of the contract. And I think that last point is the most important point of all. We've certainly seen it argued beforehand that giving due notice under the contract rather than walking out immediately amounts to a waiver of prior breaches. I've not seen it carried through into a reported decision, which is why Brown and others, and Neon Management Services Limited and others, is, I think, an important case. So, thank you very much for listening. I anticipate the next episode will be back to normal, for the normal format, 3 cases, and no Star Wars references. I said I would mention a podcast as a reward for sticking with me to the end of this particular one. A couple of years back, I mentioned a podcast called Serial, S-E-R-I-A-L, rather than breakfast. And in Series 1, went in detail into the criminal trial involving Adnan Syed, who is accused of murdering his ex-girlfriend. Serial Season 3 has just started up again, and for any lawyers, it really is fascinating. It's looking in depth at the criminal justice system in the US, in Cleveland in particular, through a combination of individual stories and cases, building up a much bigger picture. It's a really, really excellent series, and I'd certainly encourage anyone with a spare half hour to listen to episode 1 of Season 3, because if, like me, you'll be utterly hooked from the start. Hey, maybe let me know. Let me know if you enjoy it. On today's Thursday, and I am off to see Hamilton tomorrow evening, so I'll let you know how I get on with that. Musicals aren't my thing, but I kind of felt, given how much hoopla there's been about Hamilton, it would be crazy to miss the chance to go see it. So next time round, I'll let you know how I get on with Hamilton. Anyway, and of course, in the meantime, stay safe. Thank you very much for listening, and I do hope you enjoyed this podcast, and give Serial a go as well. Cheers.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.